The concerns you ask that have been raised by the immigration bar and also by one or two academics. What are we doing? Well, certainly the first thing we did was we met with the immigration bar. We have a standing immigration liaison committee, and spoke about it and invited them to give us suggestions as to how we can reduce the divergence in the rates at which different judges across the court grant leave. We met with the author of the study, the principal researcher, Professor Rehag from Toronto, and again talked about how he could possibly make the work more meaningful, and I say that in the following sense. It's hard for us to get a sense of whether this is a problem or it's a phenomenon that is basically characteristic of all areas of the law. I think anybody who thinks about other areas of the law and the subjective nature of judging will immediately intuit and understand that different judges are always going to look at similar problems somewhat differently. So our range in this study, in the rate at which individual judges grant leave applications, I think is something like from 2 to 62. But if you take one judge out of the equation, it's from 2 to 28. So that's a 26% variation. Is that a large variation relative to other areas of the law? Relative even to the immigration area in other countries? We don't know. So we encouraged Professor Rehag to look into that, because certainly if we're outliers relative to other areas of the law or other jurisdictions, that's something that we'd like to know. In any event, it is an issue that we perceive as being a troublesome one, because it does have a fairness dimension to it. If a person comes to this court and seeks leave for judicial review, there's a fairness aspect to a fairness side of the coin, if you will, maybe, to this whole issue of, well, they'll have a 62% chance if it's one judge, or a 2% chance if it's another. And I really think if you focus really on the 2 to 28, because if we take the one judge out of the equation, it's really 2 to 28. Even that has somewhat of a fairness, an undeniable fairness aspect to it. And so what we're doing is, first of all, welcoming input into what, if anything, we can do about this. And we're going to talk about the leave test, and we're going to talk about the standard of review. I think what will happen in this meeting is exactly what happened at similar types of meetings that I participated in over in the OECD, where just like judges who are supposed to be independent and who are independent, countries are independent, and one country can't prevail upon another country to take a certain position. And those were the rules of the game at the OECD, that countries wouldn't do that to each other. But what we did do over at the OECD was discuss different perspectives, meet and discuss, because the OECD is a forum for exchange of information and cooperation. And as countries sat around the table behind their flags and spoke about their perspectives on any given issue, inevitably what we would see over time is greater convergence, because people would go away from these meetings with an enriched understanding of different ways of looking at issues. And so I'm hoping that something similar will emerge from this meeting on Friday, where we all sit around and discuss the test for leave, the Supreme Court's recent jurisprudence on the standard of review and what the Supreme Court has been saying about deference. The Supreme Court has been sending some pretty strong signals to the rest of the country about the need for greater deference and what deference means, and narrowing the range of decisions in respect of which a correctness standard of review applies. And I think it's important that we discuss these things, because our leave grant rates, I think, are a function of three things. One is, are people applying the right test? Two is test in terms of the test for leave. Two is, are they thinking about the standard of review in the way that the Supreme Court is telling us we need to think about the standard of review? And three is what they bring as a person to the job, their own personal values and way of looking at things. Now that can be changed by having a conversation, to some extent, by having the type of conversation that we're going to have. But really, it's the first two things that I think are more within our purview. I personally can tell you that I have, on a number of occasions, had my own hand stayed when I was tempted to intervene and quash a decision and send it back. I was stayed by what the Supreme Court has been saying about deference and the need to think carefully about whether a decision is reasonable in fact and law, whether it's within the spectrum of reasonable outcomes in fact and law. And they've put some flesh on the bones in recent cases involving Newfoundland nurses and Alberta teachers, Norman and Smith versus Alliance Pipeline. And my sense is that they're sending us a very strong signal that we should not intervene unless we really do think that the decision is unreasonable as they define it. It's this range of variation that is the issue, if there's an issue. Certainly, we would like to see greater convergence, but that doesn't mean moving only one end or the other. That means trying to get a better understanding of different perspectives, a better appreciation and enriched understanding of different perspectives on the leave test and on the standard of review, in the hope that over time, after people go away enriched by the discussion, we will see reduced variation at both ends. Because it's the variation that has the fairness aspect to it, not the fact that there might be a higher rate than some people would like to see at one end, or a lower than some people would like to see at another end. It's the variation that has the fairness. The actual outcome is what it is, assuming that the law is applied correctly and reasonably.
And the fact that you're at the low end, at the 2%, what about that? Does that mean the court is going to be heading in your direction because you're the Chief Justice?
Well, I believe in this process that we're going to have on Friday, and I am very open to going away. I'm hoping I will go away enriched. I'm hoping everybody will go away enriched. And if going away with that enriched understanding of different perspectives results in me having a higher rate of granting leaves, that's great. I just, on each and every case, apply the law honestly as I see it at that time.